Yes, Mr. Mayor.
So I had just been dealing with the issue of damages as an adequate remedy for Sports Direct. Can I, before getting on to balance of convenience, deal with the issue of damages as an adequate remedy for the club? Because it was suggested by Mr. Singer that there was a separate ground of appeal in relation to that subject. And with respect, there isn't. If you don't
There's no ground of appeal in relation to what?
Damages, whether damages have been adequate remedy for the club.
Correct. Yeah. There isn't any such ground of appeal. If you look at the grounds of appeal, tab 2 of the core bundle.
The grounds of appeal, the judge, the cat got the abuse point wrong, and the cat got balance and convenience wrong.
Correct. And the only paragraphs where my learned friend has had a tilt at the relevant paragraphs he referred you to, paragraphs 63 and 67 of his skeleton argument, he did so in the context of serious issue to be tried. So I was a bit surprised to hear it was now being suggested that the cat had got it wrong to conclude that damages would be an adequate remedy for the club. There's no such point. But I'll address it in the context of serious issue to be tried in any event. And that means, I think, that the first item, when looking at balance of convenience, is the item at 34.2, which in my submission is actually the most important starting consideration, particularly when you bear in mind Lord Hoffman's approach in the Ollind case and the essential exercise of looking for the path that looks for the least prospect of irremediable injustice. And that means the relative harm of imposition or non-imposition of the injunction is the dominant consideration. And you have my first point, which is if we're wrong that damages are an adequate remedy for Sports Direct, we nevertheless suggest that the extent of damages that are uncompensatable, its reputational harm, is vague and minor. And that's what then has to be compared to the potential harm to the club. And here, context is very important. Sport Direct is a mature business, and it is a multi-product, multi-line business. Replica kit is stocked across a range of Premier League clubs, international clubs, Barcelona, Real Madrid, all the big names, maybe some substantial championships clubs, etc., alongside a whole range of other products, running tops, running shoes, sporting equipment, etc. By contrast, the club's operation, its repatriation or reintegration of its club shop, is a startup. It's a startup business that the evidence shows is hobbled by lack of historic data, because it doesn't have any data from the time that Castor ran the club shop. It doesn't have any data from the period before that when Sports Direct ran the club shop, which it did until Castor took it over. It's keen to improve engagement with its customers, to obtain customer data, to improve the sales, cross-selling, all of those kinds of commercial activities, to be in charge of product quality, queries, and all of those matters. And all of that's covered in the evidence. And it's that startup operation in relation to what will be effectively a single brand shop selling principally replica kit, but other diffusion branded club clothing and club memorabilia, Newcastle mouse mats, the usual sort of thing that you get in a club store. It's that startup operation that will be potentially hobbled or impeded by any loss of supply of what is on any view the most important line items in the club store, which is the club's replica kit. If the order in question removes all or most of the kit, that's obviously going to affect fan footfall and the success of
Well,
the
it's
club.
not suggested that it removes even most of, is it? It's 50,000 out of 350,000.
Well, you have to be very careful with those numbers, my lord, because those numbers embrace replica kit, but it also embraces so-called training kit, and beyond that, simply club-branded clothing. Replica kit, in its core form, is the home strip, the home top, the home shorts. It's the primary away strip, top, shorts, and it's the tertiary strip that you wear when your away colours clash with the home team. So your third top kit.
So they're training.
So there's 3 sets of shirts.
Training away home.
No, home, away 1, away 2.
Away 1, away 2.
Replica kit is what's worn by the players on the pitch.
Yeah.
There are then so-called authentic kits. I show you the schedule. They're indicated by AU. They are, in effect, exact replicas in terms of the high wicking material, etc., of the high-performance fabrics worn by the players on the pitch. The standard replica kits are not exactly the same as the kits worn by the players on the pitch. So there's a difference between authentics and replica kit. And then beyond that, there's training kit, which is what's worn by the players in their training ground that will be seen by the press and public when they're allowed in to watch the players train. And then there are things like anthem jackets, the jacket that you wear when the national anthem's being sung before you strip down to your ordinary playing kit, so-called travel tees, what you get on the team bus wearing in order to travel to the match, and the club parka jackets that the manager prowls the touchline in, all those types of matters. They are not, in our submission, replica kit, and they are a long way in terms of commercial significance away from the core kit in question. Now, of all of the club-branded clothing ordered by Sports Direct, their order is in fact concentrated in the replica kit area, and they don't take, for instance, the same extent of club-branded clothing as the club itself does. So it's misleading to compare the number of items ordered across the two. What you actually have to do is to look at the actual relative percentage of the particular items in question that are being asked for in the order. And that was an exercise we did before the judge and is before you. It's in the supplementary bundle. It's a pull-out spreadsheet.
Which page?
It's at tab 36, I think it is. 36, page 313. It's an A3 spreadsheet.
Yeah.
And let me just take you through a couple of items so that you see the sort of points that arise. Can I ask you to start with entry number 5? Entry number 5 is Adidas NUFC H jersey Sen 51. That's home jersey, seniors as opposed to juniors, 51. And this is comfortably the largest line item ordered by both the club and by Sports Direct. You see the club.
What does the 51 denote? Is that just the stock number, or?
I think so. You can see the order placed by Sports Direct for that is in total 15,990 out of an overall order of 72,621. Now this is, if you like, the trophy item. This is the home adult top.
Sorry, where's the 72,000?
That's in the column
H. Column H.
H, yes.
Ah, okay, thank you.
And you can see the column AF at the end, 27.2. That tells you the percentage of the home shirts that is being sought. So in relation to home shirts,
Under a third.
yes, it's not 14% at all. It's 27%. Then you go to the away jersey, below that, 6, and the relevant numbers are 5,980 compared to the club's order of 35,000, and you get to 22%. And you can work your way through the core kit items the core replica kit items, the next one in terms of sales is the junior jersey, item 8, 24%. Then it's the home jersey junior at item number 4. That's 50%. 50% of what's being sold is being ordered by Adidas, by Sports Direct. Then item number 5, in terms of relative importance, is entry number 7, Adidas NUFC away jersey junior 44. There it's 31%.
I don't understand that. 50%. Is it item 4? How does that work? 5,840 ordered. Club has ordered 18,000 odd.
I'm sorry, the relative, there are two numbers. I'm sorry, I'm confusing you, man. The overall total is column I, 31%. What item IAF was the percentage of the items as first landed. So, as was being sought before the CAT, effectively, they were asking for 50% of the items that would arrive to stock the shop immediately upon their arrival. And it's 31% once later deliveries are taken into account. So column I is the overall absolute number, and column AF is the number that would be available to the club at the time that the relief was being sought.
But just to be clear, column AF has now fallen away because, as I'll come on to later, we're now not seeking anything other than delivery when they get delivery. So I think for this purpose of this submission, it's really column I that's the material.
I think it's important to understand what the dispute was before the tribunal below, to understand why we were raising concerns and why there are concerns about workability. Because the first concern is what percentage of the stock it's going to be, and the second that you have, and the second is what percentage overall it is. But in any event, even if you just concentrate on column I, what immediately jumps out at you is that the core kit, replica kit items, have considerably higher percentages than 14%. And that's because, in relation to other items, like the pre-match T-shirts, etc., the order volumes are very, very much smaller. And so too are the order numbers, for instance, of the authentic jerseys. So if you look at item 15, for instance, these are the authentic, more expensive jerseys. And there it's just 410 out of the overall order of 6,617, or 6.2%. So what the percentages my learned friend is keen on conceal is the relative weight of the order, which is all concentrated in the core replica kit. It's much more diffuse in relation to the club branded clothing. And of course there are lines of club branded clothing in the 350,000 products being ordered, which Sports Direct don't take at all. And all of that reveals, and this is the point we made to the tribunal below, that there is huge variability in significance of these items. A core case in relation to replica kit is understandable, but once you're down to anthem jackets and things like that, it's very hard to understand, particularly when it's evident that certain items are massively less significant than others. And a very good illustration of that is if you compare the number of home jerseys being sold, 72,000, with the number of home shorts. Remember the item my learned friend describes as shirts, but is in fact shorts. There are in fact 20 adult shirts ordered for every single pair of shorts. And plainly fans don't think it's essential when attending St James's Park to be wearing shorts, notwithstanding the Geordies' famed love of the cold. So that is an indicator of the fact that the product mix is itself diffuse, and we still don't understand the basis on which the club branded clothing, when you get to the pre-match T-shirts and matters like that, are wrapped up in this injunction. The tribunal chose to take the matter in the round, and we accept that.
Would it help you to see what order they're seeking?
So, the order that they're seeking arrived 2 minutes before we came into
I
court.
haven't got it.
I asked my learned friends if they've got paper copies, but let me
don't-
describe it as I
I don't
understand
need
it.
a paper copy. I need an electronic copy.
Yeah. As I understand it, what they are seeking is effectively this, which is a kind of hybrid of what they sought and what the CAT proposed. What they're seeking is the delivery, as and when it arrives, of the percentage of the overall order shown by column I. So if, for instance, your 72,621 home jerseys arrive in 5 tranches, each time a tranche arrives, you will pass on 22% of that tranche to Sports Direct. If there's 1 tranche, there's 1 calculation. If there's 5 tranches, there's 5 calculations. What's not explained is how this is going to work in relation to those core products that have sizing balances within them. So again, look at 5. You can see the order of 15,990 is composed of jerseys that are small, medium, large, extra large, double extra large, 3 and 4 times extra large. We don't know what is sought in relation to those. Presumably, they also seek, but it's not implicit or explicit in the order, some kind of ratioing obligation in relation to those particular items. But it's a very good taster of the kind of granular way that they're now seeking to effectively grab the club's supply and have it passed on to it. All of this is going, even in this attenuated form, to impose a substantial logistical burden on the club. The club is not set up for wholesale distribution. The practical reality is whilst it has the wholesale rights, wholesale distribution is affected by Adidas. So the club is going to have to staff up and resource to go through each order as it arrives, take out the percentage, work out what to do if the numbers don't round, how to do rounding and all that kind of things, how to do the various sizes, and then arrange for freight to Sports Direct, payment of which we presume Sports Direct will accept that it's on the hook for payment. And all of that is going to occur at the very time the club is preparing for the first relaunch of its store on the 7th of June. And the club is gearing up itself for the first time to engage in its own retail operation. And it's going to occur in circumstances where some of these items, even now, the percentages being sought are not some kind of minor rounded percentage, but are extremely substantial. 33% of the junior home jerseys, 31% of the home junior jerseys, 22% of the home senior jerseys, 1 in 5 jerseys. You can immediately see.
But presumably you're doubting, are you, that they really want all these if they're not getting, any exclusive period?
I don't doubt that they want them because they say that they do, but these are the sorts of volumes that they're seeking to get on the basis of past exclusivity. And of course, jersey demand being relatively inelastic, particularly at the beginning of the season, if you get the stock at the beginning of the season, you're likely to be able to sell it. And that's why having the stock at launch is so very critical, because most of the stock flies out the door in the month following launch. And so, to an extent, given that it is a largely inelastic demand, exclusivity is one part of having control over the stock at the time of launch. Now, on any view, working out...
This is a question that will demonstrate my ignorance of the way these things operate, but is the replica kit different each year?
Yes.
It has a year on it, does it, or what?
Yes, it's different each year, just like Christian Dior is different each year.
So people do buy a new
top each season.
top each year.
A particularly keen fan will buy a new home top and away top if they travel to away matches. They might buy home, away 1, away 2. Their children are big fans. they'll buy children's kit, they'll even buy the shorts because the
What
kids buy
about
the
the
shorts.
away 2? What's the difference between away 1 and away 2?
It's when it clashes. So if
It's
your
when it
away
clashes.
one strip is red and you're playing Liverpool, you have to switch into some puce green or whatever it is. So
Why
that you
doesn't
don't clash.
Liverpool switch into...
Because they're at home.
away team
The
that's
home side always plays in its home
No,
kit.
no, I understand. I'm just joining my lord in the ignorant.
I actually know somebody who had an entire section of their wardrobe devoted to the home and away strips of the particular team that they supported, going back for I think 20 years.
Yes,
For
people.
each year.
You assume I don't.
And that person's a High Court judge, isn't he?
I couldn't possibly comment.
Sports fans collect all kinds of things, programs, kits.
Yeah.
Yeah.
There's lots of ways of showing support, and of
No,
course, all
the
of these
bottom
items.
line is the important bit is my lord's question that it's new every year, and
It's new
then
every year.
lots of people buy it every year.
It's new every year, and lots of people buy it every year. That is indeed the important point. But the other important point is that the percentages of the most important or valuable items are far higher than the 14% figure.
Is there still a big market in rip-off kit? In other words, non-genuine kit, so fakes.
Yes, there is. Yes.
There is, and that used to, when I was, I was going to say young, but when I was a barrister, that used to keep
Arsenal
the
and
Chancery
Reed.
Division happy.
Arsenal and Reed in all those cases, the stalls aren't outside the ground anymore. They're all online. That's
Right.
the problem.
But
They're
you-
probably all speed freighted from China. I think that's where the counterfeits originate from on the Far East, and they're just mailed.
But that's still going. That's a still big
Absolutely.
trade.
And it's one of the things that an IP owner has to invest in to try to close down as part of their brand protection.
All the more reason actually to get your kit out early in the season before they have a chance to copy it.
Absolutely right, my lady. Absolutely right. So this 50,000 out of 350,000 number is completely misleading in my submission. The real focus is on how much kit is being taken in particular product lines, and in particular how much of the core products, the core jerseys and shorts are being taken, and it's substantially higher than that. And that, of course, ties in directly with the fact that the exclusivity in the Castor agreement was for launch of the home kit rather than in relation to pre-match T-shirts or anthem jackets or matters of that kind. So that's the scenario. And so when we come back to this question of loss, and you ask, what's the loss to the club store? You've got a one-trick pony club store selling club kit, having up to a third of its kit taken away. That is obviously going to impede its ability to service its customers and do all the things that the Two Circles report suggests that the club wants to do that are perfectly proper and about building a more valuable business relative to an outsourced operation. So that's the first problem. The second problem is, of course, a displaced sale is a displaced sale from whom? If Sports Direct get a shirt, which of Adidas, JD Sports or the club has lost out in the sale? How do you work that out? That is a huge imponderable. And then, of course, you have the fact that the relief being asked for effectively requires a breach of the JD Sports agreement. Now, in one vague view, that agreement is unenforceable, but if we're in the terrain of us complaining about our loss, we've been forced to breach a valid exclusivity agreement, and many consequences of that are plausible. It's plausible that JD Sports will treat it as a breach. We've seen evidence that says that's their analysis. It's plausible that they'll terminate. It's plausible that they'll seek to renegotiate. It's plausible that there'll be all kinds of consequences, including on the knock-on arrangements with Adidas, who've effectively agreed that sales through JD Sports should count as, in effect, sales through the clubs and count towards the club's minimum order quantities and matters of that kind. Now, the sums of money that we're being paid for exclusivity are substantial. They're seven-figure sums. I can give you the numbers on a sheet of paper if you want them. I don't think anything turns on them. We all agreed they're substantial sums of money. The royalties that are payable under the networks of agreements are substantial. The royalty rates vary depending upon the success of sales. And you can immediately see that the royalty calculations in such a scenario are going to be extremely involved. And then all of this is a risk to the club's guaranteed revenues. And it all occurs in a world where football finance is more fraught than it has ever been, where if you don't balance your books, you may find yourself in the Everton or Notts Forest scenario of points deduction or worse, and you may therefore have to trim your expenditure to cater for the risks in question. And that is the sort of imponderable loss that lies at the end of all of this, and it is of a completely different order of magnitude to the kind of, well, we might have lost some cricket bat box or cricket bat sales in consequence of not selling replica kit.
I think it's fairly unrealistic to put your clients in the same league as the owners of clubs like Everton or Nottingham Forest.
Well, there's financial fair play or profitability and sustainability investigations to all kinds of clubs.
Yes.
It's not just...
You know, you've got Saudi money backing you, so...
That's not the point, with respect, my lady. It's not how much money your backers have at the end of the day. It's how much money is legitimate in the club and how much is generated by its own revenue, because that's how the profitability and sustainability rules work. And the key thing is, replica kit is an absolutely critical part of the revenue, which you then have to balance against expenditure on players and matters of that kind.
Right.
So the fact that the PIF is worth hundreds of billions of pounds isn't here nor there at the end of the day. The club has to, in broad scheme, live within its means as generated by its footballing activities. And one of its football activities is selling replica kit.
And your club shop is a startup, you said?
It is a startup. We don't even have sales data for the previous year. It says we've had to estimate what we think the likely levels of sale are using our best efforts because we don't know what Castor sold in the previous year. So then you go back to paragraph 34.2 and you do the exercise of weighing relative harm. My learned friend criticises this analysis on the basis that it's a focus upon long-term business damage. We don't understand that. If it's damage, it's damage. If it's unquantifiable, it's unquantifiable. Whether it occurs today or in 6 months' time doesn't much matter. And indeed, reputational damage, which is what he relies on, itself is inherently long-term.
But why did the tribunal say they placed relatively little weight on the point when you're saying it's absolutely critical not to compare? You're not comparing apples and apples when you compare the club shop startup with JD Sports.
I agree, my lord, and
Sorry,
that follows from the that follows from the criticism that we make of how the tribunal dealt with the adequacy of damages for JD Sports. Once you accept that there is either total weight in that criticism or real weight in that criticism, it means that the importance of the factor in 34.2 in our favour is undersold. And to the extent that that assists me, I do make that submission. It is undersold. Because the party that is most at risk of uncompensatable, real and substantial damage if the injunction proves to be unjustified is my client. So that's 34.2. 34.3, consumer benefit. This point falls away completely once you appreciate that effectively Sports Direct is asking for the butter and the money for the butter. Because what they're asking you to do is assume in their favour the narrow market definition and all the facts that they say should be assumed in their favour about how prices are going to change and consumers are going to be harmed, but not assume as equally viable, equally realistic country worldviews that the market is in fact much more widely defined and that the agreement is a classical vertical exclusive agreement that facilitates more effective competition between retailers and generates all kinds of benefits for both consumers from that more effective competition and for the IP owners. So, for instance, one of the things that JD Sport agreed to do is to give store prominence to the particular item, or to agree to have it stocked in a certain number of stores, all of which are valuable benefits to somebody wanting to ensure that their products are seen and sold as widely as possible and deliver consumer benefits.
Is this point that if one is doing the counterfactual for the purposes of assessing the balance of convenience, the one exercise is to say, if the injunction is not granted and it turns out that their case is right and it's a narrow market, what's the loss to them? When you come to looking at the counterfactual, you say, well, if the injunction's wrongly granted, then you win on the wider market and on the basis that there is a vertical agreement that generates benefits. Is that the point?
Not quite, my lady. It's a variant on that focused on consumer benefit. It really comes down to this.
Right.
If they've won, then they've probably established that there is a detrimental effect on competition that hasn't been justified. And so consumers have lost out in that way.
Yes.
If we win, and the most obvious way, there are many ways, but the most obvious way is we establish a wide market definition, application of the vertical agreements block exemption order to exempt the agreement, end of, etc. If we win, it's because the agreement is effectively in the round pro-competitive. And what the tribunal is saying in 34.3, and it's the only thing it can say, is that we can't prejudge that factor because it's the central issue in the whole exercise of competition justification. Now, there might be some cases in which you could land at some kind of evaluative judgment on that. Let's say that the evidence was clear evidence of a cartel. Cartel agreements aren't, except in truly extraordinary circumstances, capable of justification. But this is a vertical agreement. Vertical agreements are widely accepted to be pro-competitive in a variety of circumstances. That's the reason why there is a vertical agreement block exemption order, and before that, the vertical agreement block exemption regulation when we're in the EU. Vertical agreements are accepted to be potentially and very often pro-competitive. All the tribunal is saying is, in those circumstances, we can't reach a judgment on where consumer benefit lies. The point is neutral. And that reasoning, in my submission, is utterly unimpeachable. Anything else is effectively an invitation to decide the final merits for trial conclusively now or substantially.
So which paragraph are you saying is uncontroversial?
34.3.
34.3.
No consumer. And is there a block exemption nowadays?
Yes.
Post-EU?
Yeah. Yes. It's called the Vertical Agreements Block Exemption Order.
Simulated law.
And it all turns on market share in the relevant market. And if the relevant market is wider than Newcastle's replica kit, there's every chance that the relevant market shares are going to be below the threshold.
And it's a simulated law.
No, this is a domestic block exemption order made after we left.
It's a new block exemption.
Correct. I see Mr. Bailey's nodding. Professor Bailey, that makes me much more comfortable, but that was my recollection. It's very heavily modelled on the vertical agreements block exemption regulation, which has been updated since we left the EU. Right. So that's 34.3. 34.4, it is a mandatory injunction. We were careful not to put any formalistic weight on that. It was us that was citing Appellant below and saying that the mandatory prohibitory distinction is not a formal one. It just requires an investigation, because what Lord Hoffman says is the sort of generic truth is once you're into mandatory injunctions, the capacity to cause harm that's potentially irremediable is much greater. So tread with greater caution in relation to mandatory injunctions. And that's in substantial part an answer to my learned friend's case, which is, well, these are handed out to a penny in refusal to supply cases, that you still have to go through a careful investigation. And one of the real issues here, we'll see when we come to status quo, is the fact that there is no prior trading history between the parties. And that leads to the practical concerns here, which I hope showing you the schedules will give you a taste of. The minute you get drawn into granting an injunction, one way or another, you're going to get drawn into identifying just how much stock in particular items are going to be delivered. You're going to be drawn into deciding whether or not the stock levels should reflect those levels that were achieved only by dint of the previous launch exclusivity. And you're going to be policing the relationship, because we're not going to contract with Sports Direct, still less on their terms and conditions, which we haven't even seen yet. So all matters like payment, late payment, poor quality delivery, late delivery, etc., are effectively going to be supplied by court-mediated terms. And that's a function of the fact that we don't have any prior trading relationship to fall back on.
Is there any precedent for that?
I don't believe there is, because the previous cases, like AAH and Pfizer, are circumstances where there was a prior trading relationship between the parties, and the relationship being falled back upon was in the terms and conditions of supply that previously operated. And that's why we say this is an important point, because it's going to make the injunction hellishly difficult to police. And that's
normally the courts don't make contracts for people.
Exactly. Exactly. And why should we be forced to contract upon their terms and conditions to which we have never even historically agreed? So that's 34.4. Then we come back to balance of convenience. And the reason I take them in this order is that in my submission, when you read American Cyanamid, the balance of convenience is a tipping factor. It's a deal breaker in what would otherwise be something akin to a close tie between how to weigh it up. It's not, in my submission, actually the place that you should be starting the analysis. It's what you do to split cases that are otherwise, the pros and cons are nicely weighed. And of course, identifying a status quo is a notoriously judgmental exercise. That's point one, and not for that reason one we suggest that the court should readily interfere with. And you have all the points that I made beforehand. You have the point that the arrangements that are in issue are the prior arrangements with Castor. They were entered into by the club at the time that the club was controlled by Mr. Ashley / Sports Direct. So the arrangements that are effectively being sought to be continued are arrangements that were made by Mr. Ashley and Sports Direct in substance at the time they controlled the club. That's highly material, we say, in circumstances where the ownership has changed. And that's the point that is rightly being made in 34.1. And then what we have is no continuity of the previous arrangements. It's not like the AAH case where the previous terms of supply are revived. We have terms and conditions that we've never seen agreed with Castor, revived, but with the excision of at least, we don't know because they haven't provided any details of how they contracted with Castor, excision of at least the practical arrangements for exclusivity. And that, in my submission, is not status quo. It's making something that is entirely new between undertakings, both of which has changed. There's been changes in the undertakings on the defendant side because the club is no longer owned by Mr. Ashley. And there's changes in the undertakings that are contracting because Castor and the club are not one and the same. That's why the tribunal is quite right to say that the status quo is really that pertains from the adoption of the new arrangements. And that point in my submission links directly to the first point we raised by way of our respondent's notice, which is the topic of delay. Because by the 11th of October 2023, Sports Direct knew that it would not be obtaining supply from Adidas. They sent an email saying Adidas will not be supplying us.
Well, why did Mr. Singler tell us that you held them in as late as December or January, I can't remember, that they were thinking about the order. You were thinking about their order.
What happened, and it may be helpful to look at the correspondence, because I think the account you've been given of it is perhaps not an entirely full and fair one. What happened was that this dispute started with inter-solicitor correspondence. There was a letter from Fraser Groups sent.
I mean, could you, before we just get into
Yes.
reams of solicitor correspondence, could you just say what your case is on the correspondence?
Our case on the correspondence is that right from the get-go, the correspondence identified a lack of urgency in this case because the relevant ordering deadline had already been missed. The relevant ordering deadline was always orders had to be placed in October. That was the date Adidas set for new orders. Sports Direct claimed in their evidence that the orders could be placed as late as December if it was placed by a manufacturer, and Adidas has come back and said, no, that's not true. We don't care whether the orders are placed by clubs or by retail outlets, the orders have to be in by October. And funnily enough, that's when Sports Direct, we know as a matter of fact, placed their orders for Adidas kits in relation to Manchester United and Arsenal. So they ordered Arsenal and Man U kit in October, just when Adidas said the window was. They did nothing to take forward the issue of the club's kit until contact was made with Amanda Staveley. The contents of that discussion are hotly disputed. If you read our defence, you'll see that the allegations in relation to pricing intentions, etc., are denied. There is some awkwardness about dealing with that issue because the context of the conversations were without prejudice conversations in relation to other litigation, which might give you a flavour of what's going on. That's the context of the discussions. After that, the order arrived in Mr. Silverstone's department out of the blue in December. And the initial correspondence in January was a letter before action from Fraser's Groups making a basic case under competition law of we're an existing customer, it's a refusal to supply, the kind of axiomatic case that was advanced below. And Mr. Devine, the club's general counsel, answered that letter on the 25th, some 6 days later, saying, we've had trouble dealing with this beforehand because of a cyber attack over Christmas. It's all under consideration. But then they simply answered on the topic of interim relief, page 77.
Sorry, of what?
77 of the supplementary page, tab 7. And the point is simply made, damages are an adequate remedy. The window has been from orders have been missed in any event. And there can't be any basis for the urgent relief you're seeking.
To answer your Lordship's question, the reference I was alluding to was on page 1 at the bottom, which he skated over. The club is still considering your order.
Absolutely.
That letter.
Yes, page 1, which he didn't go to, the final paragraph. The club was still in the process of considering your order.
So the context of this is that the letter before action has arisen, and effectively a holding response to the threat of injunctive relief is provided. And beyond that, the club is saying, wisely, I would suggest, when confronted for the first time with competition law allegations, we're still considering your order. In other words, we're still considering the issue. The next letter is from Fraser Group again at tab 8, page 79. Short letter. That prompts a response on the 5th of February of an equally short nature. And then the substantive response is on the 12th of February. And this substantive response deals with the allegations in far greater length, beyond the topic of injunctive relief, and deals with the substance of the competition allegations. And in the context of this letter, it's explained fully and clearly that the club has concluded exclusive relations with JD and contracted with Adidas, etc. Now, to characterise that, as my learned friend did, as some kind of disingenuous response, etc., is not a fair reading of the correspondence. The real delay here is the doing of nothing between the closure of the Adidas window and December, because that inactivity basically meant that the only conceivable target for the injunction was going to be supply from the club's own order for the club's own purposes for the club's own store. And that delay is intimately related to the topic of status quo, because once you've let the known order window expire in circumstances where you know that there is a new manufacturer in situ and you know that that manufacturer has the window of orders in question, and you've
How do
placed...
they know about that in October?
They knew about it because they placed their Man U and Arsenal orders at the same time.
No, how do they know that there's a new exclusive distributor?
They knew that they weren't going to be supplied by Adidas. Because Adidas told them at a trade meeting. Told them at a trade meeting, and there's an email back.
Okay, you make it sound as if I've read the entire
I'm so
bundle
sorry.
that was provided yesterday evening when I was out all day yesterday, so the answer is I haven't.
I'm so sorry.
So just help me with answering the questions. Without, it's not a submission I'm asked, sir.
No,
trying to understand the facts.
Your point is entirely fairly made. My apologies, my lord.
Yes.
The references in our skeleton, there was an email from the 11th of October from somebody who'd been at a meeting, I can't remember his name, with Adidas, and immediately mailed back. What's the reference? It's supplemental bundle, page 192. It's probably helpful to have a look at that. Going to the horse's mouth. From Ben Dickinson back to Mr. Nevitt, amongst others.
What page, sorry?
Page 192 of the supplementary bundle.
192, thanks.
Just wanted to make you aware that Adidas currently plan for Newcastle to be club shop only for 24-25. Rolling 52-week cost of sales for Newcastle as a franchise is at 1.7 million, with poor supply and availability from Castor. So this presents a massive loss of business for the group. But knowing that they weren't going to be getting any supply, notwithstanding that they're an existing customer.
So that was 11th of October.
Yes.
What's the response to that?
That's back to head office at Sports Direct. And they do nothing. Now, their evidence originally suggested that they tried to engage in negotiations with the club in October and November. That allegation has been withdrawn. There was no contact by Sports Direct with the club at all until the Amanda Staveley conversation in December, mid-December. They simply sat on their hands. And our point is, that's the crucial period when you should be saying, I must have supply, because that's when the orders have to be placed. And by doing nothing, you make the new arrangements into the status quo. Because the club is entitled to plan for the future operation of its new club store, to order the stock it requires for its club store, and it sets in train and sets in concrete the relevant commercial decisions to underpin that venture.
Well, was there anything in practice that they could do after the... maybe I've got my head around the wrong dates, but I thought you told us that the Adidas deadline was the end of October.
It was, my lady.
Right, so in practical terms, they can't, whether they sit on their hands or they don't sit on their hands, from the end of October onwards, the only practical way they were going to get hold of the kit to sell was either from you, out of your order, because you placed it within the deadline, or persuade Adidas to change their minds.
Or they seek an order requiring us to make more orders or matters of that kind, even if the stock won't arrive for the launch date, because orders can be placed after October. It's just that orders have to be placed in October for the kit to be ready on launch date.
Right.
Mm-hmm. And there's detailed evidence as to the Adidas order windows.
So orders can be placed after October, but in order to meet the kit launch date, you've got to get in by the deadline.
Absolutely. And their whole case has always been, and this is again the incongruous tension with Castor, we have to have the kit at launch date because launch date is the critical window for the 60% of sales,
Yeah.
etc. That's why we say delay is a relevant factor. The tribunal identified the relevance of delay, but said there was in effect not sufficient evidence, didn't enter the ring in relation to the evidence on delay. And as to that, we say, for all the reasons in our skeleton, expanding the point from our respondents' notice, the evidence was absolutely clear. They knew the kit windows, they did nothing, and in consequence is the relationship was set in aspect with Adidas and the club, the volumes were ordered, and that's why, quite properly, the first response of the club in January when threatened with the litigation is, it's all too late, you've missed the window, this is not a proper case for injunctive relief. And as an initial response, that can't be faulted. The fact that then to deal with the complicated competition law arguments, you take a couple more weeks to come back with a carefully lawyered and considered response is no answer to the charge of delay, in my submission. So that then leaves the Castor issue. And the Castor issue is relevant in two ways. It's relevant to understanding whether there can be any status quo, what are the expectations of future supply, what are the arrangements in question between the parties. And it is deeply unfortunate that we have not even now been supplied with any of the details of the terms of supply between Castor and Sports Direct, because on any view, those contractual details are relevant, even before you get to the exclusivity that hasn't been reduced to writing, but plainly exists. I say plainly exists because there is an email from Castor itself referring to the exclusivity and saying suppliers can't be supplied until the 1 month has expired. And that tallies with JD Sports' own evidence that they couldn't get Newcastle shirts.
Where's that email?
Let me turn up the references. So you'll find all of the relevant references in paragraph 50 of our submission, internal page 14, and in particular it's 50C. Mr. Aitchison was told by Castor that Sports Direct benefited from a 30-day exclusivity. That's Mr. Silverstone's first witness statement. There's the noon email about exclusivity, and that, if you want to turn that up, that's in the supplementary bundle, tab 24. So, tab 25, page 234. So Natalie Werner is someone who works at the retailer Noon, and you can, Castor, she's emailing Mr. Kimber and various other people, and you can see, hi Tom, one to add, due to the FDI exclusivity period, Noon, Namshi the retailer, can't go live with the top until the end of July. Brilliant, thanks Natalie, I've shared with the club. That's then forwarded to us further on the 26th of March 2024, FYI, on the exclusivity. This is Castor itself admitting the existence of the exclusivity, and admitting effectively it's been policing it with the retailer. And 50C3 also documents the fact that JD Sports said it was their understanding that there would be such a 30-day exclusivity. And there is in fact a further reference, if reference be needed, because Two Circles had ascertained this to be the position in their investigation of the current supply arrangements. And you can see that in supplementary bundle tab 3, page 47. And if you look in the first column of this document, you can see that second bullet point in the first column, under Castor, wholesale represented a heavy percentage, it's well north of 50% of sales, with volumes predominantly through Sports Direct, largely due to an exclusive window on the new shirt, JD Sports and Fanatics. And that makes both the point that it was the exclusivity that improved the volumes, and the point that in fact JD Sports, Sports Direct is not the largest retailer, it is the club. What Sports Direct is the largest of the non-club retailers. And it is due to the exclusivity in substantial part it had in place with Castor, which shut out JD Sports from the launch period. But the point goes wider than that, because we say this point is really a clean hands point. Or a source of the goose is a source of the gander point, because the essence of the Chapter 1 complaint is directed at exclusivities. It's a complaint that anything that shuts out a material competitor to the market is necessarily unjustifiable. On any reckoning, JD Sport is Sports Direct's biggest national rival in relation to replica kit. And if there is any force in their competition analysis, and let me be completely unambiguous, we say there is none, but if there is any force, it's impossible to understand how our exclusive arrangements with JD Sports are invalid and cross the line, and yet this exclusivity, albeit for a shorter period, but targeted at the particularly important lucrative launch period, is not. And that's particularly so when you take account of all the things that Sports Direct are fond of telling you. They're the biggest. They've got the widest array of shops. They're the price discounters. They're the home of football. Well, all of those points become utterly poisonous when you consider the Castor agreement. And that's why we say that this is a clean hands point. And once you understand that it then taints the volumes sought for supply and still sought for supply in that column I, the point becomes fatal. And we say the tribunal had everything before it needed to grasp the nettle on that point. And that is a solid, indeed unanswerable, equitable basis to refuse relief in this case. And those 2 points then, delay and clean hands, really seal the deal on the balance of convenience analysis. You get to a position where the club is the one most obviously at greatest risk of loss. You have a highly intrusive injunction that's going to require court rules to set the terms and police. You have balance of convenience that's fixed by delay back in October 2023. And you have a party coming to the court with no clean hands, not even revealing the existence of the Rangers exclusivity agreement, which is reduced to writing and is equally inconsistent with their competition analysis until effectively the day before the hearing. And their only answer to whether or not they had the same arrangements in place in relation to the club is to say, well, there's nothing in writing. There's no formal written agreement. And that is, I mean, as we said in our skeleton, that really takes some difficulty in understanding, because the exclusivity is, on any view, an extremely valuable commercial benefit. How can it be that such exclusivity can have been conferred, and yet there is no trace or track of the consideration for such an arrangement? It's murky beyond words.
Well, it might be said it demonstrates what I think you described elsewhere as a coziness of relationship.
Indeed, but then that blows apart.
If there isn't anything in writing, that may be because it didn't need to be in writing because they were so close.
Yeah, well, that blows apart any argument for Castor being a safe place to locate the status quo. That's the problem, because then you're going back to.
But I mean, I think you mustn't overstate their case. They don't say Castor is the status quo.
No.
I mean, they haven't said that to us. They may have said it below.
No, we don't.
But what they're saying to us is the status quo is precisely what the tribunal said, plus the fact that we buy some kit.
But what's their entitlement in those circumstances? What's the legitimate expectation? What level of supply is it? On what terms and when? Why would they have any?
All I'm putting to you is their case, not answering your questions, which is not. But their case is they have been supplied with kit to sell in their shops for 20 or more years, and that is in addition to what the tribunal described as the status quo, which was the new ownership of the club and the desire to revamp their trading situation, was the status quo. And I mean, it's more helpful if you answer that than if you answer the case that Castor is the status quo, which they don't say.
My point, my lord, is that isn't a true status quo. You do look for status quo at the nature of the relationship most recently subsisting, rather than back over 20 years. And you can't make a kind of mélange status quo where you take the bits of the previous agreement or relationship that you like and set aside the bits that you don't. And it's entirely double-edged as well, because if the status quo was one in which relationships of exclusivity were permissible, why are they entitled to any injunctive relief until the end of a 1-month launch period, for instance? If that's agreeable with Castor and them, why shouldn't the same, in essence, as a counterfactual be agreed with JD Sport? So it's very, very difficult, other than that we've always had at a supply level, which is not sufficient in my submission to found the kind of detailed order here for the kind of volumes, the intrusion onto the club levels of supply, the timing, etc. It's very unhelpful just to keep it at that very high level of generality, because it doesn't answer the question, well, what form of supply should the court order? Those are the points I wanted to cover, unless there's anything else I can help you with. I think that's my allotted time. Great.
Thank you very much. Yes, Mr. Simon.
I'll try to keep my reply brief, but there are a number of points where, with respect, Mr. Delamere either failed to answer questions from the bench or skated over some important bits of evidence. So can I start by going back to serious issue to be tried? His submissions on this were actually, with respect, quite difficult to follow, because in one sentence he says he doesn't shirk away from the fact that there's a triable issue. And then I think in another context, he said he is maintaining there's no serious issue to be tried as regards the...
That's a slightly forensic point. What he says is he would seek to uphold the decision that as things are presently pleaded and look, the tribunal was justified in saying there is no serious issue to be tried. But that doesn't mean he accepts that there could not be one when you replead your case with the benefit of further information, as at the beginning of a case like this one inevitably and often does. So he's being realistic rather than, it's not really helpful to say in response, well, you know, that's you don't understand it. Of course you understand it.
No, but my lord, with respect, the question before the tribunal was whether our pleaded case raised a serious issue to be tried. And we say, before one gets to the possibility of future amendments, we're plainly over that threshold, and that's, with respect, the question for this court.
Yeah.
Now, in relation to that, the tribunal clearly fell into error insofar as it maintained that it could only look at facts which were essentially common ground. That's actually the starting point to the problems with the reasoning. Secondly, there is no analysis whatsoever in the tribunal's judgment of the effects. And as I've shown the court, we have pleaded a case on effects, and we have supported that case with a note from an expert. And Mr. Delamere's answer was to point to paragraph 28.4 of the judgment, but as my lord and my lady, you'll see, 28.4 doesn't deal with effects at all. There is simply no analysis in the judgment of the point that we were making in relation to Chapter 2 and Chapter 1, that the effect of these new arrangements would be to distort competition in the downstream retail market. That is a complete omission from the judgment, and 28.4, 5 and 6 is all there is in terms of the application of the tribunal's principles to the facts. There's no reference to CRA, Mr. Chisholm, no reference to our pleading, and no reference to the Two Circles material or the Amanda Staveley conversations about concerns in relation to discounting. So we say clearly that there's a problem in the judgment insofar as the tribunal either failed to understand our case or failed properly to deal with it in the judgment, and it's not a matter of making amendments in the future. And another point that Mr. de la Mare says is, well, at this stage, the evidence is lacking. And in relation to that, we say two things. First of all, it's not lacking. What more can an applicant do at this stage? We had an expert give evidence as to the anti-competitive effects under Chapter 1 and Chapter 2. And there will be further material in due course when we move through the disclosure and evidence phases. So to say that we were lacking evidence at this stage, with respect, we say we did enough,
Well,
more than enough.
Can I just put to you the case that's been put against you, which is not really explained, certainly so far as I'm concerned, in the tribunal's decision. But the case against you is that it's not a question of showing objective justification once you show a failure to supply. It is a question of showing whether competition has been eliminated as opposed to affected. That's the Court of Justice's or the General Court's law, which has not been changed by Mr. Justice Mann or Mrs. Justice Rose, as she then was. And in this case, there is no case to suggest that the new arrangements eliminate competition. What they do is change the vertical arrangements from one with them to one with somebody else. And that is not eliminating in any sense competition. There may in fact be better or different competition, which is perfectly satisfactory. So you don't get over the hurdle into the question of the value judgment of objective justification. Now, I freely accept you don't really see any of that in the tribunal's decision, but you still have to answer it.
Yes.
Because it is the case that I probably accept Mr. de la Mare put to the tribunals at the time, and you can see sort of hints at it if you read carefully between the lines of the decision. And what's the answer to that?
My lord,
Because
my
that
lord,
seems to be quite a good point.
Well, my lord,
Sight.
well, only at first sight, perhaps, because with respect, there are three answers to that point.
Okay, well,
My
let's
lord,
have them.
The
That's
first is, as a matter of law, there is a dispute as to what the test is, and we do respectfully submit that purple parking, Mr. Justice Mann rejects the very same argument based on Microsoft. It was being advanced by Mr. Briley in that case, and Mr. Justice Mann rejected exactly the same argument that's being advanced. He said the test was too high.
No, but in a sense it doesn't matter, if I can just put it this way, because the fact that it's either elimination or a serious effect doesn't really matter if the case against you is that what has been put in place in rejigging the arrangements is simply somebody else having either exclusivity or not having exclusivity, but you've got Adidas, you've got JD Sports, and they are in place of Castor and Sports Direct, and the club wanting to sell its own merchandise, which it's entitled to do. And, by the way, it's not just a question of you being the big discounter who sells things more cheaply for the benefits of consumers. You sold things, most of them, in the first month exclusively, with no evidence you sold them cheap at all.
Well, can I just take you to Mr. Chisholm's report, because he deals head on with this question, that it's not good enough to say that the consumers will be supplied by the club and by Adidas and by JD Sports. It's supplemental bundle, page 202.
Yes.
And it's paragraph 44 of Mr. Chisholm. There is a contention there will be sufficient retail competition through supply by the club, Adidas and JD Sports, or there would be more competition under this scenario than takes place currently. While in principle there may be arguments why 3 retailers are sufficient, this would be inconsistent with the acknowledged strength of SD as a retailer downstream.
Well, what does he mean by that, the acknowledged strength of SD as a retailer downstream? Does he mean the acknowledged strength of SD as a retailer sportswear generally, or as a retailer of Newcastle United replica kit?
Well, Newcastle replica kit is the relevant market for these purposes, my lady.
Well, where's the evidence about an acknowledged strength in relation to the sales of replica kit when there's no detail of how much you sell or even which stores you sell it in?
I mean, you can't confuse. You can't have it both ways. You can't have the narrow market for the benefit of getting over the competition hurdle in the first place, and then have a broad market and wonderful downstream benefits of a marvellous retailer who sells everything you could possibly want for years and years and years.
Can I be completely clear? We are not seeking to have our cake and eat it in that respect.
We're talking here about Newcastle replica kit and nothing else, because that's your market.
But the evidence in relation to Sports Direct sales of replica kit across the board is that they are the discounter, and that's reflected in the club's own disclosure, the Two Circles report. That's
right, well, let's have a look at them being the discounter of replica kit.
Well, my lord, that's explained in the evidence of Mr. Nevitt, the Two Circles document that I was.
I mean, how can they be a discounter when they're exclusive sellers?
Right.
Yeah, but my lord,
I mean, 60% goes out the door in the first month, right?
no, I don't think that's not actually right. I think what the reference that Mr. de la Mare had in mind was from our claim form, which was, I think, 60% around the period of launch, so it wasn't tied to the 30 days.
Right.
But the evidence of Mr. Nevitt, which is unchallenged, is that Sports Direct is the discounter in this market.
Well, can we see that then?
Yes, my lord,
Let's see
I'm
that
happy
in
to
this
see.
market, because I bet it's a bit.
I mean, this actually, this point about SD being Sports Direct being the discounter is actually not.
Well, of course, Sports Direct is a discounter. Everybody knows that. Even I probably knew that before I walked into court. What I don't know is whether it discounts Newcastle kit when it's an exclusive seller of it, which I doubt.
Yeah, but my lord, with respect, we would say that's not the relevant question. The question
It's
is.
for consumer benefit.
No, but my lord, no, because what the effect of these new arrangements is that Sports Direct will be entirely excluded from selling Newcastle kit. Not for 30 days, not for the period around the launch, for the whole season, next season, pending the trial.
I mean, the problem is this is a very unusual, specific market, and it's actually not. No, that was. It's actually not an answer to this case to say, well, you can get. We're the big discounter, and we sell Newcastle replica kit 6 months after it came out at knockdown prices, because nobody wants it 6 months after it comes out, because the matches have gone, and the if I can be rude here, the kids, the young people who want to wear it to be in a la mode, again mixing a number of things, they want to wear it at the time when it comes out. They want to be the first to be wearing these jerseys, and so saying that you knocked it all down and sold it cheap and that's consumer benefit 6 months later really doesn't get you anywhere.
No, my lord, well,
So
first
let's
of
see
all,
what
Is
Mr.
it
Nevitt.
paragraphs 23 to 25 of Mr. Nevitt?
Which page, please?
180 to 181.
yes, exactly. Thank you, my lady. But my lord, can I just come back on what your lordship just said? Because the sales of the kit take place throughout the season,
Of course.
and what the effect of the new arrangements is going to be is that we'll be excluded. Sports Direct will be excluded for the entirety of the season.
Well, that's true.
And so, my lord, the 30-day point is actually, with respect, not directly relevant to what the effect of the new arrangements is going to be. The Two Circles report at page 47 of the supplemental bundle.
Well, let's do one thing at a time. Let's have a look at Mr. Nevitt.
Yes, so
Let's say
Mr.
that
Nevitt
he gave
explains.
these critical evidence.
Mr. Nevitt explains at 23.
23.
Sports Direct has a very specific strategy, which is to be the best value retailer and to make heavy use of price discounts. And then he goes on to say they'll always look to offer the lowest price.
Well, he says that they benchmark the prices against other sellers of replica kit. So if there is no other seller of replica kit, you wouldn't be benchmarking it against anything.
My lady, I accept that Mr. Nevitt doesn't say in terms, this is the way we price in the first 30 days, or this is how we price in the first...
He then goes on to say, we'll always look to offer the best price, and if we can't do that, well, we'll try to throw in a couple of extra shirts, buy one, get one free, or something like that. Then he says we don't keep any permanent records at all of these benchmark prices because they're not relevant. That's our business strategy. And then he says, but our pricing of replica kit may be comparable to that of other retailers over the course of the season.
No, he says over the course of the season, SD will inevitably offer consumers the lowest prices.
And then he says that he shifts all the old stock.
Yeah.
Well, then 25 is directed at the end of the season, isn't it? When you've got a whole load
get rid of all
of
the old
stuff you want to try and get rid of, so you flog it off
But my lord,
cheaply.
but the new arrangements will mean that no kit will be sold via Sports Direct. That's the crucial point.
Yeah.
But he doesn't say anywhere, I think I'm right, in the first month we discount.
No, I accept he doesn't say that. I accept he doesn't say that. But again, I stress that's not the right question, because the consideration here is that no consumer will be able to buy a Newcastle kit from Sports Direct at any point in the season. So we don't accept the 60% figure in the way it's been put. But even
just try and address, I mean, I get all that, you're right. But Mr. Singler, what I was asking you is to address head-on the case that Mr. de la Mare has explained to us. And just to repeat it very briefly again, that is that the competitive situation which provided consumer benefit before is replicated and may be exceeded by the new arrangements where it's not you, but it's JD and Adidas and the club who are selling the replica kit. And whether the test is one of elimination or very serious harm to competition doesn't really matter to that. You have to show that competition is eliminated or very serious harm is done to competition by the new arrangements. And what is being said against you is you don't get to first base. And I now perhaps understand better than I did when I walked into court this morning that that's probably what the tribunal was saying as well. But of course the tribunal's an expert tribunal that has got this running in its blood, which I no longer have.
well, my lord, as to what the tribunal was thinking, none of this discussion appears in the judgment. It's 28. We looked at 28 quite closely.
Yes.
That's all framed in terms of our complaint being the change of arrangements, which is not actually our complaint. And the list of factors is not about the effects. I'll come on to address your question about effects. But as regards the judgment, I don't accept that this is what the tribunal really had in mind, because there's absolutely nothing in the judgment which grapples with the Microsoft test, the purple parking point, Mr. Chisholm's evidence on effects. There's none of that. So I wouldn't accept for a moment that the tribunal in 28 is dealing with, will there be sufficient competition if JD plus the club make the sales?
Okay.
But
backing up a moment, in answer to my lord's point about the need to show elimination of competition, you said a little while ago now there were three answers, and I think we've only really got as far as number one.
No, my lord,
As a matter of law,
there's the question
there is
of
a dispute as to whether Microsoft is the test.
that's the first point. The second point is the references in Mr. Chisholm's first and second report.
Yeah.
So I showed you paragraph 44, but he did a reply note, and paragraphs 25 to 27 deal with that, 296, 297 of the bundle. And then the third point, my lord, is the fact that this is manifestly a triable question. And in that regard, I'd like to show you, I've mentioned it, I'd like to show you this court's judgment in the job serve case, which is Authorities tab 3.
Yeah.
And this is Lord Justice Mummery dealing with a refusal to supply case in which an injunction had been granted at first instance. One can see that 214 of the bundle.
214 of the
No, that may not be. I'm so sorry. It's page 35 of the bundle of the Authorities 1.
45.
And paragraph 3 you'll see. Well, paragraph 2 you'll see it's an abuse of dominant position. Paragraph 3, the first instance judge held there was a serious question to be tried, and the balance of justice favoured the grant of an interim injunction. Paragraph 4, you can see the point that arose on appeal. And then paragraph 5, the pleadings in the action disclose that there are issues of fact which cannot be resolved at this stage in the action. There'll have to be a trial of these issues. And the crucial paragraph I'd like to show you is paragraph 12, subparagraph 1. As I see it, the present position is this. In general, abuse of a dominant position is a complex question of mixed fact and law, which should be determined at trial on the basis of tested oral and documentary evidence and rival submissions, rather than in the summary setting of an application for an interim injunction. And so we do say, first of all, there's a dispute about what the relevant standard is, but secondly, we've done enough in terms of the evidence, factual and expert evidence that was before the tribunal. And then finally, I will come back to the two circles document, because it's really rather important on the question of whether Sports Direct is in fact a discounter of the Newcastle kit. It's very important not to lose sight of the fact that the whole driver behind these new arrangements is the concern about discounting. So that's page 47 of the supplemental bundle. Going down an exclusive route will limit our distribution options in the UK, most noticeably with Sports Direct, whose discount pricing model would impact our own retail operating margin significantly. And so...
You've just got to let me catch up.
Oh, I'm sorry, my lord. It's page 47 of the
Page
supplemental.
47.
Is this the
Yes, it is, the slide.
PowerPoint
Yes.
presentation.
Yeah.
Two
And
circles.
which part of it is it?
It's the bottom right-hand corner of the
Oh,
slide.
Under
Going
further
down.
Going down the
implications.
exclusive route.
Okay.
And one has to remember that we're talking here about bricks and mortar stores. So JD and SD have 400 plus shops across the UK. That's why they're the nationwide retailers. And therefore, we do submit that we have an arguable case that if you take out SD, then JD is really the only show in town so far as...
So where's the evidence that SD stocks this kit in all its stores?
Well, there's no specific evidence of every store that it sells.
That it used to do that.
Sorry, Mark.
That it used to do that. Is there any evidence?
Not in terms, but it's implicit in Mr. Nevitt's evidence that. I mean, Mr. Nevitt explains clearly that it's a nationwide retailer.
Mr. Nevitt is very careful about what he says
Yeah.
and what he doesn't say.
Well, this point has never been raised that Sports Direct only stocked Newcastle kits in some of its stores. So the evidence before the tribunal was that you've got Sports Direct and JD with 400 stores across the country. Mr. Silverstone's evidence is that the club wanted to do a deal with JD in order to have access to that wide distribution network. And our simple point is, if you want wide distribution, why are you excluding Sports Direct entirely? They are the like for like in this market, JD and Sports Direct, and that's really the long and the short of it as regards the elimination of effective competition or a substantial removal of a competitor downstream.
I thought you tried to explain to me they weren't like for like this morning.
No, but as regards replica kit, my lord, they are, because you may have online sellers, but JD and SD are the bricks and mortar like for like, and the Venn diagram where their business models overlap.
What about Adidas? Does it not have shops?
It has,
sure
I think,
I've seen shops with Adidas.
It's described as a flagship store in London, and Newcastle have 2 shops in Newcastle.
Adidas. Oh,
No, Newcastle. So in terms of the other players in the market, I think Mr. Silverstone's evidence is Adidas has 1 or more flagship stores in London. Newcastle has a store in its club at the ground and 1 in Gateshead.
You forced me to Google it in a minute.
Well,
Yeah.
yes, I'm reminded Mr. Nevitt does say, paragraph 53,
Yes.
that since January 2017, SD has recorded sales of 7 million worth of club kit in its Newcastle stores, as compared with 2.5 million in other stores and 9 million online. So there can't be any serious suggestion that SD is only selling in a limited part of the country.
Well, he makes the point in the context of the comparison with JD. There's several points earlier in the witness statement, I think paragraph 10 and 17. He doesn't give any figures, but he does say that Sports Direct sell far more outside the hometowns, in other words, outside Newcastle itself.
He does.
They will be selling Newcastle replica kit in a far wider range of their stores elsewhere in the country.
Exactly. But my model, one has to, with respect, take a step back. The test is serious issue to be tried. It's a low bar.
So let's assume for a minute you're right about that, because I think there was a sort of tacit assumption. Mr. de la Mare will leap up in a minute and tell me not to make any tacit assumption. But there's a sort of tacit assumption that you could get over the serious case to be tried. What's being said is that it really, on a balance of convenience, it can't possibly be right to disrupt this start-up business. And I know I maybe sounded cynical about the description, but the new arrangements, which whether start-up or not, are new serious arrangements for rejigging the distribution of this kit, make them break their agreement when there is a flimsy case for a denial of supply, because what is really happening is what I put to you a few minutes ago, is a replacement of one major retailer with another major retailer, a revamping of the club shop, and a manufacturer who will also sell to the public.
My lord,
No real effect on competition.
the difficulty with that is that the tribunal didn't consider effects at all, and it didn't consider merits to be relevant to the balance of convenience.
It did consider effect. I mean, it said there wasn't a very strong case for saying there was a consumer harm.
No, it didn't, my lord. I'll come back to that point. I was just on serious issue to be tried. I think we're now moving to balance of convenience. But
the problem is with all these things, and we see this judgment which splits up serious issue to be tried and damages being an adequate remedy for one side and then the other, and then balance of convenience. But the truth is, this bench has probably heard more injunction applications than you've had hot dinners. And it's not the way it's done. They're all interrelated. Of course we read Lord Diplock and we understand it and we have that running through our veins. But you can't just say, I win on serious issue to be tried, therefore I win the appeal.
no, I understand that.
You may not.
No, I understand that, Lord, but I was going to take these in headings.
Yeah.
And I was just focusing on serious issue to be tried, and we say there's a triable question as to the extent of the effect. And I was just trying to explain.
Okay, because I was put right when I said to Mr. de la Mare, and he may be right about this, when I said, look, if you lose on serious issue to be tried, we've got to look again at the balance of
Yes.
convenience. And he said, no, you haven't necessarily, because they looked at it on the basis that they were wrong about serious issue.
No, well, I don't accept that reading of the judgment, my lord, because actually balance of convenience is dealt with, as we know, in one paragraph, 34, and status quo is the only thing that actually points clearly in favour of, in the tribunal's view, dismissing the application.
They had no reason to go to the rest of the cyanamide test unless they were doing it on the counterfactual. That's the problem. I mean, judges don't make findings for no reason at all. They may have been against you on serious issue to be tried, but the fact that they actually went down the line of dealing with damages being an adequate remedy and looked at the balance of convenience suggests to me they weren't going to stop at that point of the inquiry.
No, I'm going to come on to those other points, but just my Lord the Master of the Rolls asked me about the discounting. Can I just remind you of 29.1, because it's not right to say the tribunal didn't engage on discounting or dismiss this as a neutral point, because as a matter of fact, at 29.1 of the judgment, they said that they'd made clear that they accepted as a fact and have proceeded on the basis that Sports Direct prices would undercut by a material amount the prices of Newcastle United, Adidas and or JD. Whilst we accept the factual assertion, we consider it to be immaterial. So I think, my lord, you were putting to me that the tribunal did consider effects and rejected the idea of consumer harm.
They said it was immaterial.
My submission is they accepted what we were saying about prices over the course of the season being lower. And in fact, what one doesn't see is how does that fit into the competition law analysis? Because what they haven't done is consider any of our evidence or pleadings as regards the effect on the retail market. But to the extent they have dealt with it, they've actually accepted that prices would be lower. That's why we say that we're clearly over the serious issue to be tried threshold. And then when it comes to balance of convenience, we say that the tribunal was right about damages being inadequate for Sports Direct, and Mr. Nevitt, his evidence in his second statement at paragraph 49 to 53, he explains, as my Lord Justice Flo put it, the three heads of loss, and it's that third one which the tribunal ultimately holds is not quantifiable in damages. And one has to remember we're talking about the whole season's worth of exclusion. So what Mr. Nevitt explains is that if Sports Direct is not able to stock Newcastle kit for the entirety of a season, it will lose reputation and credibility in the eyes of the fans. Customers will then be lost for the replica kit and for other items, and not only on that one occasion when they come in to buy the kit but they're disappointed, but on future occasions as well. And he says in terms some customers might never come back. And that's the evidence that the tribunal accepted.
It's pure speculation, isn't it? I mean, whether it was accepted or not, I mean, you just simply don't know. But it seems to me that the idea that somebody's going to throw their hands up in horror and say, because Sports Direct doesn't stock the replica kit of my favourite football club, I'm not going to go in there to buy any produce ever again. It's just daft.
But, well, my lady, that's the evidence of Mr. Nevitt of Sports Direct.
It says quite a lot about the evidence of Mr. Nevitt.
Well, with respect, what he's giving evidence about is consumer behaviour in this market. And if I perhaps just show you those paragraphs, one can see that it's not evidence in the abstract or theoretical or speculative. He refers to the tribalism of football fans and the importance of being seen in the eyes of fans as the home of football. It's paragraphs 49 to 53. Page 187 is where the section starts. And he says these effects can occur based on a short-term impact, but can have a very long-lasting effect. I think at 52, for example, even a short period can be enough to put off fans from using particular stores. And he gives the example of Celtic and Rangers fans and the boycott of the stores. So the tribunal, we say, was entitled on the adequacy of damages to Sports Direct to adopt and accept what Mr. Nevitt was saying. I mean, obviously, we're at the interlocutory stage, and it's difficult to see that Mr. Nevitt could have really made the point any more clearly than he has with his experience of years of operating in this industry as to how consumers, and in particular Sports Direct's consumers, behave. And he gives a reference to JJB at 49 as well. So this is someone who's calling upon years and years of experience of a particular industry.
It's 51 and 52, Mr. Singler. There is a strong likelihood that you'll lose customers. It's not just that these customers won't come. They might not come in on other occasions to buy other goods because they might switch loyalties when they go to somebody else. It's more because of the loss of reputation that these are customers who might never come back.
Well,
that's the highest he puts it.
My lady, at 51 starts, there's a strong likelihood that SD will lose customers when they have to buy the club kit at other stores. Not just that these customers won't come in, also they might not come in on other occasions.
Well, hang on a minute. I think the first sentence is focusing, isn't it, on loss of customers, because the core thing they're going to do is to buy the club kit. They're going to go somewhere else to buy it. Yes. And then all he's going on to deal with is the situation where they might also buy something else other than club kit. And so I don't think he is putting it any higher than it. To the extent that they might also buy other things, it doesn't necessarily follow they will, but if they might, then they might go off somewhere else.
Then he says if they do go somewhere else to buy their club kit, they might then switch loyalties because they've managed to find a Newcastle kit at JD, and therefore they might stay with JD. But if JD doesn't stock the same sorts of things as SD, which it doesn't, well, then that's rather a false analogy too.
My lady, first I would say that's not a fair reading of the strong likelihood, but also there's obviously a limit to how much detail he can go into on an interlocutory application. But the second point I'd make is that there are two questions. Would damages be an adequate remedy for Sports Direct, and would damages be an adequate remedy for the club? Now, on a like-for-like basis, the evidence from the club is not any stronger than this. And that's, in one sense, inevitable in this sort of exercise. What they say is there might be this consequence if an injunction is granted, or there might be that consequence. So it's not really the case that they have put their evidence on...
They're going to be forced to break their exclusive agreement with Adidas.
No, there's no exclusive agreement with Adidas.
With JD.
But that will be compensated. Well, you have my submission on that. There's a real question as to whether there would be a breach where the supply to Sports Direct flows from a court order. Secondly,
illegality is not usually an answer.
No, it's not. No, so it wouldn't be illegality. It would be a defence of.
We can't perform our contract with you because the court has told us we mustn't. Isn't always a very good answer.
But the second line would be that it's compensatable in damages, because if they have a remedy, it would be the cross-undertaking that we've offered extends to JD. So that JD point, we say, it really is... so the evidence on adequacy of damages, we say the tribunal was right as regards the evidence of Mr. Nevitt to accept that. If the tribunal was also right as regards the club's position, then this comes down to balance of convenience, including status quo, and the one factor being, in the tribunal's mind, decisive, being the status quo. And now, on status quo, I do respectfully submit that the right analysis is not to focus on Castor, it's to focus on the fact that there has been supply for decades, and it's ultimately within the gift of the club to ensure supply to Sports Direct next season. That's why the tribunal says the club is the right defendant. And in circumstances where both Sports Direct and JD have been supplying Newcastle kit for the last 5 years, we say plainly that is the status quo. From the consumer's perspective, they've had the ability on a bricks and mortar basis to purchase from Sports Direct and JD. And as a result of these new arrangements, that will not be possible, not only for the first 30 days, but for the duration of the season.
Can I just put to you, Mr. Singler, the way I see it at the moment, to see what your answer is. Let's assume for the moment that the tribunal at least expressed itself in a little, with a little less clarity than it could have done, because what it was really saying was there might be a serious case to be tried at some time in the future. At the moment, you haven't got over that hurdle, but the case is very weak. It's got to be speedily tried. Everybody acknowledges that. Mr. Ashley is not likely to back down, but it's a pretty weak case because competition in one side has been replaced by competition on the other, and therefore, whilst it may be right to say that both have a certain degree of unquantifiable damages, when you do your balancing exercise, you put into the one balance that the case is not that strong, which you're allowed to for your Diplock's analysis. And balancing it all up and looking at the way the consumers will be affected, there is no reason to interfere at the moment with the new arrangements. Get a speedy trial, and if you're right, you'll get the kit back next year. You're a big outfit. You sell a lot of kit and a lot of other things as well. You're unlikely to be affected at all. They may be affected very badly. So the balance of convenience lies against you. Now, could you just tell me why that, if that had been the reasoning, which maybe it was, maybe it wasn't, it wouldn't be quite persuasive?
Because, first of all, the characterisation of the case is incorrect. So what's happening is not the replacement of one with another. It's the club wanting to sell a greater proportion themselves and excluding Sports Direct completely.
But they're allowed to, I mean, whether they're allowed to exclude Sports Direct depends on the basic point, but they are allowed to take it in-house, they're allowed to change the arrangements, you don't have a contractual right.
No, but with respect, the premise of the question in terms of the weakness of the case was on the footing that the case is that they've replaced Sports Direct with someone else.
Yeah.
They haven't done that. What they've done is they've completely excluded Sports Direct so that they can increase their share.
Same thing, isn't it?
Sorry, my lord?
Same thing.
Well, no, my lord, because in terms of the competitive dynamics in the downstream market, you've lost, on any view, a very substantial player. So it's not the same thing. This is actually really quite important, because if the club wants to sell more itself and exclude Sports Direct, who would be a competitor in that downstream market, that's not, in competition law terms, replacing one with another. It's exclusion.
Well, you see, I've put it to you that they've replaced Sports Direct with Adidas and JD. Castor didn't sell direct, did it?
Castor didn't sell direct, but JD has always been selling.
It did sell direct.
Castor did sell direct. Castor did sell direct.
Castor, as I understand it, ran the shop.
Yes, exactly.
Oh, right. Okay.
But I think they also sold online directly to consumers.
So
So all that's happened is Adidas is now the manufacturer in the place of Castor. JD was selling directly to consumers and will be. The club actually already had direct sales itself.
So you say effectively all they've done is exclude you.
But my lord, I cannot stress how important that point is.
No.
That's really...
The club, whether it's for Castor or direct, is still going to be selling as it was before. JD Sports was already selling.
Exactly. My lord, this is...
And Adidas is simply what Castor was, if you like, in terms of online sales, etc.
My lord,
Some of their own
Well,
shops.
it's got their own.
my lord, yes, and this
They've
is
got
really
23
quite
shops.
fundamental to
I mean,
the case.
the difficulty with the argument, your argument though, is that the percentages will be different, won't they?
Yes, no,
Because they'll need
no,
to
I
meet
accept...
up your
Sorry, 26.
No, because if Sports Direct...
15% or whatever
Exactly,
it was.
no, of course, but that's exactly what the club was trying to do. It wants to increase the extent to which it makes its own sales,
20.
and we've seen the rationale for that is it doesn't want Sports Direct playing in that market because it drives prices down. So this is really quite important. It's exclusion of a downstream competitor, a very substantial player, and as I say, for this purpose, bricks and mortar purposes, it's only JD and Sports Direct. And they've decided they want not to bring everything within the club shop. They do need a UK-wide retailer, but not Sports Direct. And so the premise of the question, that this is a weak case because it's really like for like, that's absolutely not what's going on. It's kicking out a very substantial player, and essentially from 1 and 2, Sports Direct and JD, the bricks and mortar operation goes to JD only. And that's why the tribunal did, to be fair, accept that there would be consumer harm, because if these kits were not available in Sports Direct for the duration of next season, a speedy trial will not deal with next season. So that's why the tribunal was right to conclude and proceed on the basis that if Sports Direct can't sell next season, consumers will be worse off. Now, they ended up dismissing that as an immaterial factor, which I'll perhaps move to that point. We say, in the context of a just and convenient question, the question for the court is, what is the balance of convenience? What's the course that would cause the least irremediable prejudice? Sports Direct will be shut out of this market for the entirety of the season. You've seen what Mr. Nevitt says about the consequences of that. The status quo is, on any view, however one wants to look at this, on any view, there has been decades of sale. And that's, so the focus on Castor is misguided, because Castor was only the manufacturer of the last few years. But this has been going on, this relationship and the supply from Sports Direct to consumers has been going on for decades. And the competition between the two bricks and mortar players, JD and Sports Direct, has been going on for at least 5 years. Yes, the precise routes may have changed as the manufacturers get replaced by one another. But if one takes a step back and says, well, what is the status quo? It's the availability of Newcastle kit in Sports Direct stores. And that may disrupt to some degree on the tribunal's
Well, I
reasoning.
think you can go a bit further than that. You can say the status quo is the availability of Newcastle kit in your stores and JD's stores.
That's the critical point, my lord,
Yeah.
because that comes back to the effect on competition. The critical point is the competitive dynamics need to involve JD and Sports Direct. And
Is JD, I mean, you said the last 5 years, JD's only had the kit for the last 5 years, is that right?
well, the evidence says that for at least the last 5 years, both of them have had this club's kit.
Right. I mean, which, they both,
2017.
right. I mean, one of them's a newer company than the other?
Not that new, I don't think.
Not that
new. And so on any view, we say the status quo properly analysed involves supply by Sports Direct and competition with JD for bricks and mortar across the 400 stores in the country. And what will happen to the club in the meantime, between now and a speedy trial? They will not be able to bring everything to the club shop to the extent they would like to do so, because on this basis they would have to divert some of their orders to Sports Direct if an injunction were granted. But this is not a complete roadblock, as it were, to the plan. It doesn't throw the whole plan into disarray, because they still will be able, they've ordered 350,000, I'll come on to the precise form of order in a moment, but on any view, they will still be able to go ahead in the way that they wanted to a very large extent. And so we say holding the ring pending a trial it is the appropriate course, both from Sports Direct's perspective, because it's had supply for decades, and it's had an expectation of supply on that basis, but also from a consumer harm perspective. It's no good saying there will be a pot. If it turns out that we're right at trial, consumers, as the tribunal has accepted, consumers will have paid more for their Newcastle kit for next season than they otherwise would have. And that's the pot of loss, which is not going to be recoverable. So in addition to the Nevitt evidence about the inadequacy of damages to Sports Direct, there is a pot of loss to consumers. And the club's answer, Mr. de la Mare's answer below, was, well, those consumers could put together a class action. I mean, and with respect, this is simply not a good answer in the context of a competition case to say, well, it's a neutral or immaterial point, the fact that consumers will lose out. So we say the balance of convenience for those reasons favours an injunction. And then if I can deal with the question of delay, because Mr. de la Mare, I'm afraid to say, did not give you a fair account of the chronology, and there's a limit to what I can do in the time, but I would point you to Mr. Nevitt's, well, first of all, if I show you the document that he went to at 192 of the supplemental bundle. This was the 11th of October email from Mr. Dickinson, but he didn't take you to the final paragraph, which says, Catherine Swarbrick is taking this away to try and change on the Adidas side. So on any view, there's no definitive decision being communicated at that stage. But more importantly, Mr. Nevitt explains in terms, paragraph 31 to 32 of his first statement, that there was complete confusion, and the reason that no order was placed.
182.
182, I'm so sorry. What he explains at 31 and 32 is that there was a complete lack of transparency from the club. And this discussion in mid-December was supposed to lead to a meeting, which was in the event never arranged. And one only has to step back and think, well, why didn't Sports Direct place an order at the same time as it placed an order for Arsenal and Manchester United and so on? Because of the confusion caused by the club's behaviour. And then the position gets even worse with the correspondence, to which he really had no answer. His answer was to show you selective bits of the correspondence. But let me just quickly give you 3 references. Because the way this matter first arose in terms of the correspondence was that Sports Direct were never told about the exclusive agreement. So the very first letter in the bundle is actually Sports Direct learning about an arrangement with a different retailer, Fenwick, which turned out to be essentially not what was going on. But that actually demonstrates the lack of understanding. But if we go to the 25th of January letter, page 76 of the bundle, they say, we're somewhat surprised, this is the second main paragraph, somewhat surprised that you've made the assertion that the club has made a decision to refuse to supply in circumstances where no decision in response to your order request has been communicated. It's all premature. Threatened action is unwarranted. Then the final paragraph, which I asked you to look at earlier, on the same page, says that they were still in the process of considering the order when the letter was received. This, of course, now sadly appears to have been superseded. And then if we look at the letter on the 5th of February, again, he didn't take you to this, page 81. What he didn't show you was the second paragraph. Firstly, we note you've incorrectly retitled the letter heading as refusal to supply, which is incongruous because we made it unequivocally clear that no such decision had been communicated. It's disingenuous to seek to obfuscate the substance of this correspondence. And then the 12th of February, which is the letter at page 83, is the first time they actually came off the fence and said, we've done a deal back in October with JD, an exclusive deal. And so it really doesn't lie in the club's mouth to say that we've in any way delayed. And of course, he makes the point, well, I think my lady actually asked the question, what would you have done differently, having signed up to the exclusive deal? What would you have done? He said, well, we could have placed more orders. But they didn't place any more orders. As soon as this correspondence started, they didn't start to increase any orders, which they could have done. So really what they tried to do in the correspondence was play a game whereby they said it's all premature, and then they said it's all too late. And therefore the delay point really has no merit whatsoever. And nor, finally, does the point about clean hands. Because as I've said in relation to Castor, even taking, as the tribunal said, this will obviously need to be looked at more closely on the facts at trial, but taking their point on Castor at its highest, what Sports Direct had was a 30-day exclusive period. But that is not the same as excluding Sports Direct from the market entirely. So it simply doesn't follow. He says it's a cosy agreement and so on. We don't accept any of that. At best, what this point goes to is volumes, because he says, well, I think when the Master of the Rolls asked him, well, they're not really saying that they want 30 days of exclusivity through the injunction, which is obviously right. He says, but it's all relevant to volumes. But that's the extent of the point, and that can obviously be dealt with if, in terms of the order. But it's not a clean hands point. We haven't done the same exclusive deal that they are doing with JD. JD was never shut out of the market entirely. So before I just come to the draft order and to explain the draft order, can I just pick up one point? The Master of the Rolls asked whether there was another case where the court had forced parties to contract. And there is in fact a case. There's the software cellular case, which we cited below. It's not, unfortunately, in the reduced bundle for the appeal, but we can obviously make that available. But that case was a case where T-Mobile was forced by the court on a refusal to supply allegation, forced to enter into a contract between the injunction stage and the trial. And so there is precedent for that. And as I say, in a...
on what sort of terms, though? Did the court devise the terms? Did the parties agree the terms? I mean...
it was a hybrid, my lady. It was a hybrid.
I think the accurate answer is, my lady, there was fairly standard form terms for the provision of the service in question. It's provision of the service which had been provided to other people on those standard form terms. It's about call termination.
But with respect, this point about, well, it's all very difficult, it is nothing more than an interim submission, because the question is ultimately the court has to try and do justice between the parties between now and trial. And if we have a seriously arguable case...
Excuse me, just give me a moment. Usher, could you go outside and tell them to stop banging around and shouting? Sorry, Mr. Singler.
Could I request a comfort break?
Sorry?
Could I request a comfort break?
No, well, I'm afraid there has to be, you can do it from the transcript. We haven't got time for breaks for the transcribers. I never give breaks for transcribers. And Opus knows that. And if they want, they can do it from the transcript, from the recording later. So it's not the way we operate in this court. It's not like a first instance trial where we've got days and days. But of course you may leave the court.
Have you've got a draft? Have you?
We have. I've got hard copies, and I believe an electronic copy has been sent.
I've got an electronic copy, so I think my lord should have one as well.
Oh, I'm very grateful. With Lord
I'm
Justice
still
Lowe.
using a quill pen, Mr. Singler.
Could I have one?
I've got it on the email. Thank you very much.
So, my lord, I was just making the point that really it's an interim submission that's all too difficult, and if that were a submission that had any attraction to it, that would allow a defendant to get off as it were, from injunctive relief. I mean, if the position is, on this hypothesis, we're over serious issue to be tried, damages wouldn't be adequate, the status quo is that supply should be made to Sports Direct. If all of those points are in our favour, then the argument proves too much, as it were, because it would be open to a defendant to say, oh, well, we'll throw up our hands and raise so many difficulties that the court couldn't possibly police it. So it's a rather self-serving argument. But in any event, what the draft... And can I just make this point, actually, also, because it's not right, before I come to the detail of the order, it's actually not right to say that there's been any shift of case. Can I just quickly explain that point? The original draft order was that our order, Sports Direct's order, should be fulfilled by the 6th of May. That's the version in the bundle. At that time, the club had not disclosed to us what it had ordered and what the delivery schedule was for the club. And when they told us that, in fact, they were going to get things on a staggered basis, we then put a different order before the tribunal, simply changing the dates, because obviously we didn't want to be seeking an order for delivery before they get delivery. And then the further discussion that happened at the hearing itself with the tribunal was that instead of getting all of the 50,000 items that we've ordered, it would be possible to scale that number down on a pro rata basis. So that's the iteration, the various iterations, but there hasn't been a substantive shift. We've actually tried to accommodate all of the points that have been raised against us, all the roadblocks that have been put up. And so what we seek in the draft is that they should supply the items as specified in Schedule B, which is the Sports Direct order, and the prices, which again are reflected in the original order. Those are the wholesale prices that the club itself will be paying for its own supply. And then paragraph 4 is each tranche. So as each tranche comes to the club, Sports Direct would get a fixed percentage. And then there's a provision that Sports Direct will collect and will pay the club for each tranche prior to collection. And there's a point about if paragraph 8, if any supplies are delayed. And then Schedule B, I should take you to Schedule A first. That's the cross-undertaking and damages, which was always there. We've now added a further provision to deal with Mr. Delamere's concern that Sports Direct might start selling before launch dates. It's never been our intention to do that, but that's another undertaking that Sports Direct provides in Schedule A. And then Schedule B has everything that Sports Direct has ordered, with the percentages being a percentage of what the club itself has ordered of the same item. And as I say, 2 points of detail. There were a couple of line items where Sports Direct had ordered things and the club hadn't ordered them, or they're not available. So we've struck through those rows. So the original Sports Direct order was 29 rows. This is now 26 because we've tried to remove anything which was controversial in terms of whether Adidas is manufacturing a particular product. And the percentages, it's right to say that overall we've ordered 14% of what the club has ordered. It's right to say that on an item-by-item basis the percentage is either higher or lower than that. But the point that the tribunal was putting to us in oral submissions was that...
You've broken down the sizes. I see.
Yeah.
Yes.
They still want 31% of their home jerseys.
Well, I was just about to say, but the point that the tribunal was making was that in order to do justice between now and the trial, one option would be to pro-rata down those percentages. But the way this is supposed to work is in fact very simple, because they are going to get all of these kits. They are going to pay the wholesale price, which is the same that Sports Direct would pay. We're simply saying, well, as and when you get deliveries, divert a percentage to us. And this is prepared on the basis of the full 50,000. But of course, what the tribunal was getting at was that they may be able to pro-rata that down in order to try and do justice between the parties between now and trial, so that there's some supply, but not necessarily all of the 50,000.
And that could do that as well.
Exactly, and that would be a complete answer to the concern that the Castor volumes are too high. My Lord, I think, if there's anything...
You may have seen the interesting letter from the tribunal suggesting they don't do orders.
I haven't...
They did one for the permission to appeal, but anyway.
Was the letter from them saying they don't do orders?
Well, that's what they say.
I haven't seen that.
I haven't read it very carefully, but I think it says that
The thrust of it.
The rules talk about decisions and appeals from decisions and time running from when the decision is made or notified.
I think that may be the point they made in the trucks actually.
Yeah. Well, there we are. Anyway, we're not getting one, so we'll deal with the decision in this case.
Can I just make one final point, consistent with my my submission, that a lot of what the club has said, both below and today, is inter rorem. The reference to financial fair play, I think my lady was quite right to pick up on this point, because it was floated in Mr. Silverstone's evidence that an injunction, he said, would kill off their in-house retail operation. That's paragraph 71. That's turned out to be manifestly false, because we now see the delivery schedule. It's a fraction of what the club's getting, so there's no killing off. On financial fair play, it's very carefully worded in Mr. Silverstone's evidence. He doesn't say there will be a breach, and nor could he sensibly say that. He simply floats it as a possible outcome of an injunction. But what the court may be interested to hear is that the day after the hearing in front of the tribunal, the owners of the club injected 37 million of equity into the club. So the idea that an injunction between now and trial for a fraction of the kit would create financial fair play issues is really fanciful.
Well, I think that the answer to that was Mr. de la Mare's very fair point, that it doesn't matter what equity is put into the club. It's their balance sheet and their trading profit and loss account that matters.
Yes, my lady, but we're talking about
what was being whispered to me from behind.
We're talking about one.
To this new point.
Sports Direct's order is 1.5 million.
Shall we just take it that neither party before this court is on legal aid?
Just in terms of the scale of the order, the Sports Direct order, I think the value is 1.5 million.
Yes.
And in a world where players are being sold for 100 million, this is really, it's just not a relevant point.
Well, everybody seems to be taking it very seriously for a case that's not worth any money, Mr. Singler.
Well,
It is.
I need a bit of convincing, speaking for myself, that we're in sort of Everton 10-point deduction territory.
Well,
Yes.
that's I think my lady, that's really the point that my lady was making, and I'm just echoing.
Well, is it now 4 points they got deducted?
I lose track.
If they won the appeal or not. But,
Now, have you got any more?
No, my lord, unless I can assist, those are my submissions.
Well, thank you very much. Any more for Mr. Singler? No.
Could I be forgiven for saying something about the order?
Yes, of course you may.
This is the first time.
Or indeed about the order, or any of the new cases. There was one, I think.
There's one point of fact which was wrong. It was suggested that we've never raised how many stores the Newcastle shirts were actually stocked in Sports Direct.
Yes.
This was mentioned orally for the first time. It's actually paragraph 10A of our skeleton. It was in our skeleton below. Yes, it was.
Which the answer is?
And the answer is?
Paragraph 10 of this skeleton for this hearing, it was paragraph 10C little
never
Roman
got
2.
one of those.
We just
It's
want to know the answer.
What's the answer?
How many stores?
We don't know.
Oh, we don't know.
We
Sorry.
don't know. That's the point. What we do know is that 7.5 million of stock is sold in stores in Newcastle and only 2.5 million is sold out of Newcastle. It means it's pretty unlikely that Sports Direct Truro is going to be offering a full line of Newcastle kit. And that's why JD Sports have agreed to stock in a certain minimum number of stores in their chain.
Okay, I think that sounds like beginning to sound like a rejoinder.
The point I wanted to make about the order is the order lays absolutely bare the percentages I referred to.
Yes.
And it shows in stark terms that for some lines of stock, for instance, the Adidas NUFC training jersey, item number 11, they're actually seeking nearly 2/3 of the club's entire allocation. Now, bear in mind that the rationale in the Two Circles report is not just about the sale of replica kit, it's about how to maximise the club's revenue from its club's merchandise, that's branded clothing and diffusion items like trainers, etc. And here we are with one of the diffusion items that on the pleaded case isn't even replica kit, and they're asking that we supply effectively 2/3 of our entire stock in question. And that is a graphic illustration of the impact of the order. And then lastly, I made the point that the order doesn't explain, or the mechanic doesn't explain, how stock is to be broken out if there are different sizes. And that remains the case. We're ordered to provide 16.65%, for instance, if you look at line item 6 of the Adidas away jersey. But there are different sizes. How does that 16.65% correlate to each of the different sizes? Still don't know the answer to that. And it's very difficult for the club because we don't actually have the information about the size breakdowns. That's why they're not on the orders per. Anyway,
So you don't actually have information about how many of each size
I think
the club has already ordered from Adidas. That surprises me.
not here today. No.
No.
We must have that information somewhere.
No,
Yes.
we do, my lord. But the point I'm trying to make is we can't
Presumably
give
based on the
granularity.
past form, isn't it? I mean, there are only so many people who are full XL.
Yes, but the point is, Sports Direct has made an order based upon an expectation as to the relative size of the cohort of people it services. They may have ordered
Okay.
more 4XLs than we've ordered 4XLs
I think-
in the relative size of the order.
I don't think this case is going to be decided on 4XL. But
Thank
I
God.
move on. Now,
Entertaining though it is.
thank you all very much, Council and your solicitors, and indeed your clients, for what has proved an interesting day. We will take time to consider our judgments. Now, what I want to know from you is what real urgency there is about these judgments. Is it, I mean, normally we're pretty quick in this court looking at the constituent parts of it, and I think we would expect to get you a judgment next week or the week after. Is there any reason why that puts anybody in difficulties?
The deadline, my lord, is the 7th of June, which remains
Well, we'll get it too long before
the launch date. And I imagine my learned friend, Mr. Singler's client, is going to want to have stock substantially in advance of that. How far he can
Well,
cut that
we'll bear that in mind.
Oh, great.
But there isn't any magic in some date in May we were given.
No.
No, my lord, the critical date is the 7th of June,
7th of
but obviously, as Mr. Delamere's preempted, that there would need to be a lead-in time.
Yes,
But I should have said earlier, can I thank the court for sitting so late, not only expediting this, but we've taken pretty much the full day.
yes. Well, I think it's important enough to take the full day, and we wanted to give everybody an opportunity to say what they thought appropriate, bearing in mind that we didn't have much reading time in some cases. Now, so we will take time. We'll hand down the judgment in the usual way. If there are difficult points arising from it, you are at liberty to ask for a hearing. I don't guarantee it will be provided. Normally everything is dealt with in writing, but I can see the possibility of an outcome that would perhaps indicate the need for a hearing. If that happens, we will anyway listen to argument in writing about that. Otherwise, it'll all be done in the usual way, and we will only use, and this is critical in this case, absolutely critical, because some of the decision part of it may be price sensitive. It is absolutely imperative that you limit very severely. We will not be giving permission for dozens of people to look at the draft judgment. You will use it only to agree an order as to costs. Woe betide you if it leaks, because that is a contempt of court, as you know from the decision in Council General for Wales. If we, depending on what we decide and depending on what it looks like, we may decide to give you no time anyway and just hand it down without asking for corrections. That will probably be something we'll have to think about. But otherwise, thank you all. I'm sorry to the transcribers for having denied their requests earlier, but it is to be understood by the transcribers that you are used in this court that they are here to transcribe what happens in the proceedings, and we do not adjust the proceedings at all for the transcribers. There can be 2, 3 or 4 of them if needs be, and they must set up the court with microphones in a way that is not disruptive to the court before and during breaks. We cannot delay the proceedings for that purpose. Thank you all very much.